Dear colleagues, after the break, we shall continue our session.
Отже, продовжуємо засідання і прошу
We shall reconvene after the break. Please invite the candidate to the High Court judge position, Pika Mykola Yevhenovych.
Добрий день. Сідайте, будь
Good
ласка.
afternoon. Please be seated.
Розглядається питання щодо відповідності
We are considering the issue of compliance of Pika Mykola Yevhenovych, the candidate to the High Court judge position, under Part 4, Article 8 of the Judge on the High Anti-Corruption Court. PCIe members are present. Names follow: Mary K. Butler by video, and Jessica Lloyd Thompson by video too. And the HQCJ members are present. Names follow: Dali Hartseluk is joining us shortly.
Ігор Пушнір, Руслан Мельник також доєднається до нас.
Ruslan Melnik is joining us shortly. Roman Sabotage is taking part by video.
Зрозумілий вам склад комісії, Микола
Is the composition of the commission clear to you? Yes, it is. Your rights.
One second. Jessica is here, so not on the video, but on the table.
Я назвав Джесіка Лу Томпсон
Did
дистанційно.
I say that Jessica was joining us by video? I apologize. Jessica Lloyd Thompson is present in person. Mary K. Butler is joining us by video. Clarification. Thank you. Your rights. You have the right to make motions and recusals, provide explanations with the permission of the chair, make your objections, and appeal the Commission's decisions. In the special joint meeting, no new materials are considered. And if there are circumstances that significantly affect the candidate's status, at the candidate's motion with the consent of at least 3 Commission members, a decision can be taken to include new materials to consideration. Are your rights clear to you? Yes, they are. Do you have recusals or motions to make? No, I don't. The rapporteur in your case is Volkova Lyudmila Mykolaievna. Over to you. Thank you. By the decision of the HQCJ, a competition to fill 23 vacancies of a judge's position at the High Court and Appellate Chamber of the High Court was announced. Within the deadline, the Commission was approached by Pika Mykola Yevhenovych with his application to be admitted to the participation in the competition as an individual compliant to Clause 1, Part 2, Article 7 of the Law of Ukraine on High Court, and to be admitted to the qualification test. The decision of the HQCJ Commission issued a decision to admit the candidate to participation in the competition, And the qualification test, the candidate earned 337.07 score in the qualification test. In 2009, Pika Mykola graduated from Lviv National University, named after Ivan Franko, and earned a degree, higher education degree, in law. In 2010, he earned his master's degree in law. The previous year, he earned his degree as a specialist. From 2010 to 2014, he worked as legal counselor, and from 2014 to 2022, he was the managing partner of the law firm Mykola Pika and Partners. From March 17th, 2022, Pika Mykola has been a military serviceman, and his attorney's license was suspended from December 2023 based on his application. The candidate has a professional experience as an attorney. He has represented clients before court, and he served as a defense in criminal cases and speaks Ukrainian fluently. Candidate has provided declaration on family ties, the integrity declaration of a candidate to judge's position. In February 2026, a statement from NGO All Ukrainian Association After Maidan has approached Commission with regarding the candidate. Thank you. Now over to the PCIe chair, Robert Brookhuizen.
Thank you, Mr. Chair. Jessica is your rapporteur, so Jessica, the floor is yours.
Thank you, Mr. Chairman. So, Mr. Mykola Yevhenovych, my name is Jessica Lott Thompson. I'm a lawyer from Canada and a former prosecutor. You've been introduced generally to the members of the PCIe, but I'll identify them for you here in the room. We have Mary Butler, who is on the screen. She is a prosecutor with the Department of Justice in the United States. To my far left is John O'Sullivan. He is a retired judge and former prosecutor from the United States. Mr. Robert Brookhuizen, who is our chairman, who is a former prosecutor and lawyer from the Netherlands, and Norman Aas, who is a former prosecutor and lawyer from Estonia. So together we formed the PCIe, and I'll be asking you questions today about your background. You have already submitted written responses to various questions, and thank you for your thorough responses and for the documents and materials that you have provided in advance. However, as part of the transparency of this exercise, this interview will include some repetition of topics that have already been discussed in your written questions to allow for the inclusion of that material in the public record. So please understand if I'm asking you questions that you feel you have already responded in writing, feel free to repeat the answer you have already provided in writing. It's okay. Or feel free to add additional information if you wish. Do you have any questions for me before we proceed?
Дуже приємно зі всіма познайомитися. Ні, питань
It's my
немає.
pleasure to meet you all. No questions. Thank you.
Thank you. So I'll ask you quickly about just a couple of technical issues. According to the available information, you're a member of the Ukrainian military, is that correct?
Так.
Yes,
And your
this is
military
correct.
unit filed a claim seeking recovery of approximately 200,000 hryvnia, which was described as improperly accrued additional remuneration related to combat payments. My understanding is that over 200 members of the military had this remuneration clawback or improper overpayment situation, and you took a legal position in response to that that attempt to get the return of those funds, that remuneration repaid to the military. Can you please tell me about that situation and the choices that you made in response to receiving that letter?
Дякую за запитання.
Thank you for this
Я
question.
би, власне, в даному випадку просив би, мабуть, про
So, in this
в цій
case,
частині про закритий режим.
I would like to ask for closed session to discuss this issue because I believe. So, if you have a motion to have a closed session, then we need to consider this motion in the closed session in order not to disclose information. Let us switch to the closed
Комісія разом з Громадською радою міжнародних
The Commission, together with the PCIe members, decided to switch to the closed session for this part of the questions asked by
Дякую. Продовжуємо засідання в режимі прямої
Let's continue the meeting with live broadcast. Please, Ms. Jessica.
Thank you. Mr. Mykola Yevhenovych, I'd like to talk to you a little bit about your experience and the types of cases that you've worked on. As an attorney and as the managing partner of a law office, what types of cases have you dealt with in your career? Have you dealt with criminal cases, civil, administrative? And please provide some approximate percentage or distribution of how many of different types of cases you've dealt with at different stages in your career. I will remind you, we have already used half of the time of our interview for this one question, previous question. Please be as concise as possible. We have much material to cover.
Дякую за запитання.
Thank you for the question. The approximate number ratio of cases is 40% civil, 40% criminal, and 10 administrative, 10 commercial cases. I dealt with criminal cases since 2015. I signed a contract with the Free Legal Aid Service, and it was about violence, and I provided free legal assistance. As I said, it was mostly related to violence crimes, and as to civil cases, they were related to the debt that had to be recovered. Also, there were commercial and administrative cases of different kinds. I was challenging the bans on tax documents, and I was dealing with criminal cases at all the stages. So starting from pre-trial investigation till the cassation stage. So from the beginning till the end, same goes for other kinds of proceedings, civil, commercial, administrative. And I was working since the first instance till the cassation instance, and I also wrote applications to the European Court of Human Rights. I mentioned that basically my first application to the European Court of Human Rights was positively, there was a positive ruling for me.
Can you also provide some examples of some complex cases, particularly in relation to criminal law or financial issues or anti-corruption? Any complex cases that you have handled at the trial stage, but please do not disclose any privileged or confidential information. It's not necessary to give any details, just a general idea about the areas of law and the level of complexity.
Дякую за запитання.
Thank you for the question. As for me, the cases I worked on, they were not too complicated, and there were less than 10 volumes in those cases. I would not call such a case complicated. So it would be false to say that they were extremely complicated. It was just important to get familiarized with all the materials, and that's it.
So do you have any practical experience with corruption-related cases, like from the corruption sections of the Criminal Code of Ukraine? Or have you represented clients before the High Anti-Corruption Court?
Дякую за запитання.
Thank you for the question. No, I never represented any clients at the High Anti-Corruption Court, and basically there was only one case related to the article on corruption, 191.
Okay. So can you explain, you're currently participating in a competition for a specialized district administrative court and local general courts in addition to this competition. Can you please explain your particular motivation for applying to the High Anti-Corruption Court position as a judge, given the breadth and scope of your practice is quite wide, as opposed to a narrow specialization in anti-corruption? Why do you? What's your motivation to be a judge, and what's your specific motivation to be a judge of the High Anti-Corruption Court?
Дякую за запитання.
Thank you for the question.
Загалом мотивація, якщо
Well, in general, if we talk about the High Anti-Corruption Court, I have a few elements to it. First, it's a desire to participate in administering justice at the level that allows to increase, if we compare with the courts of general jurisdiction, increase the level of internal and external trust to such an institution as the High Anti-Corruption Court. So in this case, the High Anti-Corruption Court is functioning openly, publicly, and I was in particular surprised that all the court hearings are open and we can view them. And for me personally, it's a great motivation to increase trust. As to the participation in other, and I will add about the HCC, it's also important for me. Actually, I am interested in working as a judge for last 4 years, but I got a special willingness during my military service. I could see how a closed structure was working, the state authorities were working, and I wanted to participate in this selection. About other courts, it might sound strange, but I was afraid of professional death, so to say. Many civilians who started serving with the military have this fear to stop doing what you love. So this participation in the selection procedures gave me the hope that I would go back to civilian life. And I'm not talking about the work as an attorney, but in general in the legal sphere, the work I loved and I want to return to.
So can you tell me a little bit more about how you, as an attorney for many years, you've worked in many different areas of law. When you need to learn a new skill or a new area of law, or to resolve a question that you don't know the answer for a client, can you talk to me about the steps that you take to learn about areas of the law that are completely new to you? What is your approach to continued professional learning as an attorney? And how would you apply the skills that you have learned as an attorney to the work of a judge at the High Anti-Corruption Court?
Дякую за запитання.
Thank you for the question. At this point, considering the military service, it's hard for me to keep improving my skills because a big share of time is dedicated to my military service. But when I worked as an attorney, I had a habit of getting familiarized with the court, with the case law, with the court practice. We have the website of the Supreme Court, if I'm not mistaken, where the legal positions are made public. And as far as I know, tomorrow there will be an event dedicated to anti-corruption law in Kyiv, and I hope I will be allowed to attend this event if agreed on with the commander. About the training, I can learn big volumes of information quickly, and I'm not afraid of that. Basically, for the last 4 years, I've been working without days off, without weekends. So I can say that the high complexity and huge volumes of work are not something that scare me. And so my decision to serve in the military is a good example. My circle of people I communicated with changed drastically, and I had to start performing a different kind of functional duties. And I think I managed to do it quite well for the last 4 years. I've been holding the same position, so it says that I'm quite efficient on this position. I am not transferred anywhere, and I think I will be able to quickly master another topic, another area of activity, namely one of the High Anti-Corruption Court.
I'll ask you one last question regarding a challenge that you have filed in relation to a decision of the HQCJ concerning the results of a qualification exam for a different judicial position. Can you please explain a little bit about that case? Please give the key elements. It's not necessary to give any confidential information. And also explain the current procedural status of that case. Why is that case happening? What is the current status of that case?
Дякую за запитання.
Thank you for the question. I was refused. I was challenging the decision of the High Qualification Commission, and it concerned my participation in the selection. I ceased my participation after the cognitive ability test. My score was 34.41, and the threshold was 33, if I'm not mistaken. So what I'm challenging is the fact that the quota set by the Commission was, in my opinion, contradictory to the provision 683 of the procedure for qualification assessment, and the provision from the law on judiciary and status of judges, where it said that the Commission can increase this threshold only when it comes to the specialist exams, professional exams, so the exams related to the knowledge of legislation and practical assignment. Now there is a different decision of the Administrative and Cassation Court, and a similar claim was actually ruled on in a different way. So there is a different practice on a similar case, but I haven't thought yet whether to challenge this decision. Thank you.
Can you clarify a little bit more about the current status of the case right now? Is it pending? Has the case been resolved? What is the current status of the case that you filed?
On the
19th of February, by the decision of the Supreme Court, I was refused, so my claim was not accepted. It was rejected.
Thank you for clarifying. I will ask you one additional question, a general question. Taking into consideration your career as a practicing attorney and your approach to the law, can you tell me about what you consider to be some of the most common challenges in the criminal justice system and the anti-corruption system in Ukraine? And how should a judge attempt to address these concerns in order to ensure fair processes and efficient trials?
Дякую за питання, хороше запитання.
Thank you for the question. It's a good question. What are the challenges? Well, from what I can read on the news, it's a very long period of court consideration of cases by courts.
Усунути такі,
If
не знаю, чи це недолік чи ні, але в даному випадку багато справ
if we consider it as a negative point, we might say that many cases are just closed because the statute of limitation expires, and if it's possible to extend this period or in some way speed up the process.
Скажімо так, організувати таким чином, щоб
Or organize it in a way.
Our time for the PCIe has concluded. I'll look to my colleagues and see if they have any follow-up questions, and perhaps you can continue this discussion also with the HQCJ, who will have some questions for you as well. Thank you for your answers.
Any questions on this side? Mary?
Am I? Дякую.
Back to you, Mr. Chair.
Дякую. Я в свою чергу передаю слова
Thank you, and I am passing the floor to Людмила Волкова. Thank you. I will have a few questions raised by the All-Ukrainian Union after Maidan. The first question is related to the premises in Lviv region. In particular, in your declaration for 2024, you indicate that your registered place of living is the town of Sokol of Lviv region, and your actual place of residence is the town of Horodok of Lviv region. At the same time, the place of registration of your law bureau is Heroyev Upa Street, town of Sokol, Lviv region. Could you please explain why don't you indicate in your declaration for 2024 the real estate items, the real property, and the actual place of residence? What's the ground for you to use it? And also, there is no information about ownership title of the premises where your law firm is located. May I answer? Yes, please. Yes, indeed. I acknowledge that it was my mistake. It was the first declaration I submitted in an electronic form. I indicated the registration address as the town of Sokol, but I didn't indicate that real estate item in the respective column. And when I was filling in the declaration, it's only later when I filled in the declaration for the 2025, I noticed that it's possible to choose an address as the address of mailing address, not the residence address. Since I reside at the location of the military unit missions, I do not live at that address in the declaration. So it was a mistake. At the same time, the address at which my law bureau is registered, that's the address of my registration. And as I was answering to the rounds of questions from the PCIe, I asked for the documents from my parents, and before that I didn't pay enough attention to that. So my mother provided me the documents, and according to that these documents, I'm not only registered at this address, but I'm co-owner of this apartment, and I submitted this information to the NACP. And in the new declaration for 2025, I indicated the address. So my failure to indicate the address was a mistake. So let's go back. Every real property, on what grounds do you use all of them? So the first one is in the town of Sokol, the second one is in the town of Horodok, and the third one is your address of your law bureau. Yes, the first address is the address of my registration, and I am the co-owner of that apartment according to the procedure of privatization. Yes, Horodok, that's my residence address, and at this address, my wife is also registered. What's the ground of you residing there? As a family member, my wife is the co-owner, but also her mother. And the premises of your law bureau, that's also Sokol town. That's the same. That my address, that's the first address as well. And you're a co-owner there, yes. The second question, it was already raised, but I would like to get more details. Which competition, which judge position is priority one for you? Thank you for the question. Of course, the hack judge position is a priority one for me. The material guarantees are in particular one of the reasons, as far as I know, service housing is provided, which is an important guarantee for me. And in this case, I think that it's in the hack that I view myself
можливість належно та професійно виконувати відповідні завдання, які поставлені перед цією
able to perform all the important powers. Of course, I have the experience which allows me to perform administrative justice in the courts of the first instance. I've dealt with administrative and civil cases. At the same time, I think that the hack has more narrow specialization. You are saying that you have experience, I mean experience in general jurisdictions, in the course of general jurisdiction. So overall, my experience allows me to perform functions of a judge in the courts of general jurisdiction and in the anti-corruption court. Tell us, please, why then, having started participating in a priority competition for you, you also submitted documents to participate in the competitions to other courts. Thank you for the question. Yes, it's true. I applied for other competitions. It was interesting for me. I tried to discover what will be the categories of cases those other courts consider. I don't have much experience in the with the administrative cases. I said that I probably had 10% of cases in this area. Excuse me. The question was why, after applying on a priority position to priority competition, you also applied to participate in other selection procedures in non-priority areas. Thank you. I liked the phrase, I was listening to other interviews of Duba's judge. He said to implement plan A, you should have plan B. So I wanted to consider the position of a judge for myself, and whether it's a specialist administrative court or a court of a general jurisdiction. I thought that in any case it would give me a better understanding of how the judicial fiduciary functions, and it would be easier for me to proceed within this system. So after I applied for the selection in administrative specialist administrative courts, I never excluded, I never rejected HACC competition. Thank you. And next question from the NGO is related to the disciplinary complaints with regards to you to the bar commission. Do you know this list of complaints?
The first complaint relates to your application to law enforcement that in the plaintiff conviction disclosed sensitive information. Could you clarify the situation without disclosing classified information? Thank you for this question. Yes, indeed, there was such a complaint against me. I submitted an application to law enforcement and rather than to mass media regarding failure of performing the duty on the part of medical workers. I learned this from my client. There was a fact of established fact of violations on the part of medical workers, and because it was my client in a civil case that might have developed into a criminal case, those circumstances could have a role in a criminal case. This is why I filed my application to law enforcement. No medical information was disclosed in this application. The following complaint was filed by an expert regarding your application on a falsified expert's conclusion. Was it the same expert deliberately false information? Yes, and then your client informed that she had lost connection with you. Did you fail to answer her inquiries? We were in touch, but the client, in my opinion, wanted too much attention from me. She would call me daily, and if I'm not mistaken about the case, she wanted to make a demand judge's recusal, but to my mind, there were no such grounds for such a recusal, and I answered her inquiries whenever I had time for this. I couldn't provide her with my attention 24/7. It was a client from a free legal aid, and that her case was closed. She did not refuse my services, but still she filed her complaint. Then a mistake in the court decision. Did you help to correct that mistake? Well, it was in my client's opinion. It was a mistake in my client's opinion. You don't need to give me the details. I have no more questions at this time. Any other questions, colleagues? I wanted to ask you regarding the information in your tax return and property declarations. For 2024, you state your ownership of 55 bonds as of September 2024. But is the date of ownership acquisition correct? So those bonds were acquired different periods, but for some reason I acquired them through monobank, but for some reason the data stated as you mentioned. So you were buying those bonds at different periods, but the time of acquisition was the same, and it was reflected in the digital system. Why did you not ask for clarifications from your bank? You decided to declare a non-reliable information, even though you knew that it was non-reliable and untrue. I cannot give you an answer. I haven't clarified it. So based on all information in your dossier, you have been acquiring those bonds since 2023. And there's only a year of difference. So when you saw that discrepancy in your dossier, could you inform the PCIe members, the HQCJ members about this to show that you noticed it too? Did you think about it? So until now, until today, I haven't thought about it. Colleagues. Good afternoon. One question regarding your practical assignment, if you recall it. You applied a criminal law that was effective at the time of the commission of the crime. And by the time the case reached the court, it was qualified in the pretrial by the prosecutor to a high degree. Is it a partial decriminalization for the failure to fill out the declaration properly? I don't remember how I put it exactly. If we take that particular situation, I believe that the modifications in the disposition did not cover the suspect, or failure to declare or untruthful declaration is not included in the list of offenses, and that offense could be qualified by either one or the other qualification. And regarding the increase of threshold of the disposition didn't really affect the state, so it didn't improve or worsen the status of the suspect. Is it it? In terms of questions, did you get the answer? If there are no more questions, then you've got 1 minute to state whatever you wish to state so that the Commission knows about it. Thank you to the HQCJ, PCIe, the apparatus for making this interview possible. I hope that regarding all the candidacies, the right decisions will be taken. Thank you. Thank you for your participation in this interview. The interview is completed. Stay well and